the docket as a result. Mr. Lewis, what do you want to say?
Your Honor, please report. I did reach out to my colleague, Mr. Tierney, the Sauce volunteer. He sent me a message. I'm sure Ms. Oliver can represent for the state of Ohio, but it's his understanding that he spoke with the appellate and they are seeking cert to this Ohio Supreme Court.
All right.
Yes, Your Honor, we would ask for this matter to be continued for report, just so the appropriate parties can get the filings to the Ohio Supreme Court.
When will that filing happen? Because, well, I know we have so many days to do that. Judgment entry from the Court of Appeals is April 27th. It's May 9th. Has that been done yet?
Judge, as you indicated, I am filling in for Mr. Tierney. I do believe that there's a 30-day window that the appropriate filings have to be made, so I would think that the filing or setting this over to the last week of May, certainly the filings will be made and
all right. Well, I had already set a status report on June 14th at 9 a.m. June 14th at 9 a.m. will be the status report. Now, I know that Mr. Hampton resides out of town, and so he is in a hearing. At every hearing, he is Zoom conferencing, with the exception of today, he's here in person. Mr. Hampton, I will permit you to remain on the same line and appear via Zoom at the next hearing. All right, Mr. Lewis, anything else you want to say?
Your Honor, may I please report? Thank you. Thank you, Ms. Oswald, for standing in. I appreciate the court understanding my client. Mother's pressure today, they drove up. It's shocking to us, but this is appropriate legal procedure. Explain to the family that is at the discretion of the state to seek approval by the Supreme Court to say they'll take the appeal. My client's mother has asked the court to consider modifying the bond to straight OR. We had the motion suppressed. We did go to the Court of Appeals. Mother posted a substantial cash bond with this title amount of her assets, Your Honor, of this proceeding. We do know he's out of state. All I can do is ask the court to give that consideration. The expectation that this case might have been dismissed today, and they drove in for that reason, Judge, but if not, they understand. I did tell some of our guys. He's not just one court appearance, he's always in the court and here via Zoom.
All right, Ms. Oswald.
Judge, the state had no notice that bond would be argued at this hearing this morning, so I am not prepared to respond to that oral motion. I would ask you to either set it over for a bond motion where the state can have the required notice of the local rules to prepare for the hearing, or that you maintain the bond today.
I appreciate that, Judge. I can respect that. The court wants to keep it on for the 14th. Court, I'll be filing a written motion and speak with the family about that process.
All right. Do you want the bond hearing to be before the 14th, or do you want to do it on the 14th?
Let me speak with the family first, Judge.
All right, go ahead. It's already set. It's already set.
Please support it. Family, Your Honor, is going to make that respect of the court. It's respect of the fellow judges. 14. If they change their mind, I'll follow their motion.
All right. So the defense has made an oral motion for reduction of the bond. The state wants an opportunity to respond in writing, or just respond.
I can respond in writing, Judge.
It doesn't have to be in writing, if you're asking me to continue this over and give you all a chance, we'll address it on the 14th.
Thank you, Judge.
Either way, whether it be in writing or we'll address the bond on the 14th.
Thank you.
Okay? All right, thank you.
Thank you, guys. Marcy. Thank you, Judge.
Thank
See you.
You can outside in the hallway with this, really going. Okay. Mr. Lucy, Susan?
I'm expecting the rules to be back.
Into
Mr. Jackson. He said he'll be right there, Mr. Jackson. And Mr. Bruce, he got two minutes.
Mr. Jackson?
Mr. Jackson was texting him on the phone.
All right.
Mr. McGill.
I don't know.
Yeah. And then she,
Oh, everybody's different. Yes, yeah. Okay. Sure. Yes, ma'am. Mr. Ernestine, I think you went to do something. I can't. That's all we're having.
I'll reach out to him. Thank you.
Mr. Young, you ready?
I'm gonna be on done today.
Oh. Okay.
She's not fine.
To call the docket.
Not to get stuff.
Dancing docket.
This week.
Oh, yeah.
So,
You get down.
I did again,
What she was saying.
she doesn't want to represent, she wants to stay with that.
Okay. That's, terrible. Okay. I'll wait to see you after you know.
Sure.
And I'll text you.
No, it's fine.
Oh, thank you. Good to see you. Take care.
Mr. Jackson, you ready?
Yes, good morning.
Good morning.
So,
You want to find down?
I got one meeting, Your Honor. I did file a motion to suppress over the weekend. Providing Ms. Oswald a copy of that occurs for the court.
All right, thank you.
Compliment the rest of it.
All right, this is a matter of State of Ohio versus Demetrius Betts, case numbers B 2104652 and B 2104560. Mr. Betts is not present. He's represented by Mr. Corey Jackson, who is present, and Ms. Allison Oswald here on behalf of the State of Ohio. Mr. Jackson, would you like me to call your client down? I know he's the justice.
He is, Your Honor, but we will waive this precedent for today's hearing.
All right. What would you like to say? This is a clear trial setting.
It is, Your Honor, and I think I indicated to the court when I took over the case, I believe that was the last setting that we said before, that my client asked me to file a motion to suppress. I realize now that I already filed a motion to suppress, I should ask the court for leave to file a motion to suppress, which I can also file, and I did not do that, but that was my area. Of course, we would be happy to ask to file a motion for leave to file that motion to suppress.
All right. State,
Judge, we have no objection to the filing at a time.
all right. So we have a trial date, July 18th,
Yes, Your
2022. And so, first of all, I think motions to suppress have to be filed so many days after the arraignment or 7 days before trial. Right?
Correct.
So I will grant your oral request to file a motion, or leave to file a motion to suppress. This is no surprise to the court, as I have in my notes, that you needed to obtain video evidence, and then you'd be considering whether to file a motion to suppress. So I'm not surprised by it. The state will need an opportunity to respond, and then we will set the hearing. So let's go ahead and set a briefing schedule. This was filed, I mean, it's so recent, it's not even a system yet.
That's correct. We have filed electronically.
All right, so, we'll just say it's filed as of the 9th. We'll give the state until June 9th. State's response to June 9th. And then Ms. Howard, can we get a hearing on the motion to suppress after June 9th? Do a final pre-trial consultation 30th.
So we want to move forward, final.
It may affect the dates, so.
One or two, June 15th.
No. That's June 15th.
June 29th.
22nd is booked. All right, 22nd, June 22nd.
That works for me, right?
The hearing,
Yes. All right, hearing on the motion will be June 22nd.
Your Honor, may I say, Ms. Oswald, whoever the prosecutor find out the cops are not available, obviously, we can, that date is movable, especially since I filed this motion, so thanks to the state for 22.
All right, thank you. Thank you. All right, June 22nd at 10 a.m. That's a Wednesday when I do motions to suppress. And state's response to June 9th, time made by motion. So your client is in custody,
Yes, sure.
and I presume he understands the filing of this motion was time.
I did explain that to him, Your Honor, and I explained that when he hired me on the case,
All right.
so he is aware of
All right, thank you very much. Anything else, Mr. Jackson?
that. No, Your Honor, thank you.
All right, Ms. Oswald, anything
no,
else?
thank you.
All right, thank you.
Mr. Greenberg, what do you want to do?
My client offers a plea.
What do you guys talk to the judge? Or you don't want to do that? There's a plea, Judge.
Okay. Yeah, okay.
Would you call it? Well, I would take my own notice for 5 minutes early. Good job. Good job. Is that a new suit?
No.
It looks new. You just fit in it, you little yourself down. Where's Mr. Vick?
You know what?
I don't know. It's probably in the heat. I think I should.
Mr. Greenberg. Oh, man.
I'm ready. Mr. Greenberg, I'm ready. This is a matter of State of Ohio versus Ryan Gamble, case number B210577. Mr. Gamble is present in courtroom with his attorney, Mr. Matthew Greenberg, and Ms. Alice Oswald is present on behalf of the State of Ohio. This matter was set on the previous date for a plea hearing today. I've been handed plea documents. Is this how your client wants to proceed, Mr. Greenberg?
Yes, sir.
All right, is that accurate, Mr. Gamble? Are you the Ryan Gamble named in this indictment?
Yes,
How old are you?
I'm 37.
And how far did you go to school, Mr. Gamble?
GED.
All right, so you're able to read and write the English language well?
Yes.
Have you ever served in the U.S. military? Are you a U.S. citizen?
Yes.
All right. Sir, I have in my hand a single-page document entitled Waiver of Trial by Jury. The bottom there are signatures. I recognize your attorney's signature here with his bar number. Is this your signature here where it says defendant?
Yes.
This is an acknowledgement by you that you understand that you have a constitutional right to the trial. When you sign this form, you're indicating to the court, I understand that, but I'm waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes.
Did you sign this form after consulting with your attorney about your constitutional right to a trial?
Yes.
Do you have any questions about this form? Do you have any questions about your constitutional right to a trial? I also have in my hand a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize the prosecutor's signature here, Mr. Greenberg's signature here, and his bar number. But up here, where it says signature of defendant, is that your signature, sir?
Yes.
Madam Prosecutor, would you please put on the record the party's expectation regarding the plea?
Your Honor, the state understands this is an open plea to the court on a F5.
All right. And so it's a plea is charged.
Yes.
All right, thank you. Is that accurate, Mr. Greenberg?
Yes.
Is that your understanding, Mr. Gamble?
Sorry, I don't know.
Is this your understanding that you're pleading as charged from the indictment?
Yes.
All right. Sir, are you under the influence of any medications, alcohol, or drugs today? Do you now, have you ever suffered with or even been diagnosed with any type of mental health difficulties?
ADHD and
And,
panic attacks.
all right. And were you prescribed any medications to manage those diagnoses?
Yes.
Do you still take those medications?
Not even right now.
All right. And as you stand here today, I understand you may be a little nervous, but do you feel like you have clarity of mind and you know what you're doing?
Yes.
Have you had good communications with your lawyer and understand what he's advised you?
Yes.
If at any time you don't understand something I'm saying, just like you did a few minutes ago, you said, I don't know what that means. Just say that, or stop me, or talk to your lawyer, okay? Are you presently under any type of probation or community control supervision in this or any other state?
No.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No.
Are you making this plea of your own free will?
Yes.
Now, it's my understanding from what the prosecutor said, and your attorney agreed, is that you will be entering a guilty plea as charged in the indictment to count 1, possession of a fentanyl-related compound, a felony of the 5th degree. Is that your understanding?
Yes.
Is that what you talked with Mr. Greenberg about before this hearing?
Yes.
Do you understand what this plea form says? Have you had a chance to review it and talk it over with your lawyer? Do you have any questions about it? Mr. Gamble, have you had enough time to consult with your attorney about your case, your entire case, before this hearing today? Do you feel you've had enough time?
Yeah.
Has your lawyer answered all of your questions?
Yes.
Have you had an opportunity to review and or discuss the evidence that the state has against you in this case?
Yes.
Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material, if any, to your knowledge?
Your Honor, all of the discovery evidence was provided while the case was pending in drug court before it was transferred out at the defendant's request.
All right. Mr. Greenberg, you acknowledge the same?
Yes, sir.
All right. Mr. Gamble, are you satisfied with your attorney, Mr. Greenberg?
Very much so.
Now, do you understand the charge against you, possession of a fentanyl-related compound, a felony of the 5th degree?
Yes.
You understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in this count of the indictment. And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes.
Now, this being a felony of the 5th degree, do you understand that you're facing up to 12 months in prison, up to a maximum fine of $2,500? Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand?
Yes.
Are you on post-release control? Well, if you are on post-release control, do you understand that if you are convicted of a new felony offense while on post-release control, that in addition to being punished with a new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains of your post-release control time, or whichever is greater. Do you understand?
Yes.
Since this is a felony of the 5th degree, community control is a possibility. Do you understand that I could place you on community control or probation for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions of community control, you will be brought back before me for a more restrictive sanction, which could include, among a host of things, the imposition of prison time up to 12 months. Do you understand? Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying your court costs. Do you understand?
Yes.
Any questions so far?
No.
When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by a lawyer? Do you understand that you have a right to have witnesses subpoenaed to come to court and testify on your behalf? Do you understand that trial is the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? Do you understand that you cannot be forced to testify against yourself at trial? Do you understand each of these rights as I explained them?
Yes, Your Honor.
Do you have any questions whatsoever about your constitutional rights, Mr. Campbell? Do you have any questions whatsoever about anything we discussed today? Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights? Knowing everything the court has discussed with you, do you still wish to enter a guilty plea to count 1, possession of a fentanyl-related compound, felony of the 5th degree? All right, anything in counsel before I accept the plea?
Nothing further.
All right, may I hear a statement of facts?
Ryan Gamble, on or about May 2nd, 2021, Hamilton County, State of Ohio, knowingly obtained, possessed, or used a Schedule II controlled substance, fentanyl, in an amount less than 1 gram.
Anything on those facts, Mr. Greenberg?
No disputed fact.
All right, Mr. Gamble, did you hear what the prosecutor said you did?
Yes, ma'am.
Is it true?
Yes, ma'am.
You hesitated.
Well, I mean, yes, I know it's true.
You possess fentanyl-related compound?
Yes, my intention wasn't to, be fentanyl, but it turned out it put me in another state, and so I didn't.
I understand. So you understand that you did possess a fentanyl-related compound?
Yes, ma'am.
All right. And you know that it's fentanyl?
Yes.
All right. Let the record reflect that the defendant, Ryan Gamble, was present in court with his attorney, Mr. Greenberg, and that the defendant was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ryan Gamble understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Ryan Gamble guilty as to count 1, possession of a fentanyl-related compound in violation of Revised Code 2925.11 subsection A, a felony of the 5th degree. Is there any reason why sentence should not be issued today?
The defense is prepared to waive the investigation proceedings.
All right, state the objection then.
Your Honor, I understand it's an F5. He does have 6 prior felony convictions in Hamilton County history, out of county, as well as in Kentucky. And we can run through
Same
that.
type of offenses?
Yes, Your Honor.
Do you acknowledge that, Mr. Greenberg?
Yes, I believe it. I do, and I believe Mr. Campbell is nonetheless still. Definitely.
All right. Mr. Gamble, I think that it is a prudent course of action for me to get a pre-sentence investigation report, because I want to know more about you than just what you stand here today. All right, and so I'm going to order a PSI. Ms. Howard, can we get a sentencing date? You know.
No,
Okay.
and we do it 10 o'clock.
If this, we need to do another day.
We do another day.
Yes.
We go to about the 13th. 13th? Yes.
June 13th. 9 a.m. Now, Mr. Gamble, you must go to the probation department today for a draft report for a pre-sentence investigation report. I'm gonna ask you to cooperate fully with their investigation, answer all of their questions truthfully. They will provide a written report to the court, so I can know more about you, and then on sentencing day, or maybe even before, Mr. Greenberg and the prosecutor will have a chance to review that report, and then we will go forward. Do you understand? All right. Now, it's very important that you have no new contacts with law enforcement during the course of the pre-sentence investigation. All right? All right, any questions? Mr. Greenberg? All right, thank you very much. Where's Mr. Rubenstein?
You walk in, you walk right.
All right. Mr. Waddle, is anybody seen him?
He just went outside the hallway with the interpreter.
Okay. And Mr. Bennett, he was here, and Mr. Wilkie.
Yes, we do. Okay, so I like that's the television. Did you guys really want to say?
This was a matter again, originally get a child care issue last year, so I did not have a pension, the waiver of the area. Today, and she said we were working on it. So, my client's here, was there still, his daughter. Yeah. That's what we do. Unless, of course, business. But that was just, the reminder basically was, he had 6 hours. Necessary. So they're gonna have to meet with us.
Okay. I don't know if you guys remember this, this is some key oh, this is the one, another thing we just did, Mr. Mayor, okay, Mr. Mayor. But should every
Okay.
Yeah.
We're ready when everyone's out.
Oh, I'm gonna break my own rule and I get new candidates.
It's a slippery slope when it starts with zero.
We all come on our, we all come to a meeting with that, right? What's the council on this one? Good morning.
This was originally a drug court, which I'm in that I'm not. It's not a drug court. That's all. It's best for the house. It's. I wish I could see. So that's treatment special. This is what happens, which is not the case.
You've already talked about this, and you were on board. You told me, when she told me what the deal was. So I was like, that doesn't sound like she wants to be. She said we were in agreement and send it out to the ones in 3 for 1. Like, you know, probation or.
Also, I think the building also that as well against the so that it wasn't. Yes, sir. The other makes sense today. That's good. That's Gigi. Yeah.
It's embarrassing, all these municipal judges, right? Because I guess things are so fast, right?
Be consistent and all the time. Whatever it takes. Thank you.
Thank you. All right, this is a matter of State of Ohio versus Jensen, Palacio, Gonzalez. Case number B2106406. Mr. Gonzalez is present in the courtroom with his attorney, Mr. Robert Waddle. Ms. Allison Oswald from the state of Ohio. We have a Spanish interpreter present. Can you state your name for the record?
Good morning, Your Honor. Pilar Gordon, certified Spanish.
Nice to see you. I just swear you in. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, in accordance with the standards prescribed by law, and follow all official guidelines established by this court for legal interpreting or translating, and discharge all of the solemn duties and obligations of legal interpretation and translation?
I do.
Thank you. Sir, are you Jensen Palacio Gonzalez? Can you say your name so I can hear it? Palacio and Gonzalez. Thank you. And are you the Jensen Palacio Gonzalez named in this indictment?
Yeah.
How old are you?
22.
How far did you go to school?
6th grade.
6th grade? Are you able to read and write the English language?
No.
Are you a U.S. citizen? Well, let me ask a couple of questions. I've been handed some plea forms. They're in English. Have they been translated in Spanish to you? And given the Spanish interpretation of the translation, do you understand these documents? And do you understand that you are here to enter a guilty plea today?
Él tiene que certificar que da una declaración de culpable.
If you are not a U.S. citizen, you are hereby advised that conviction of the offense to which you are pleading guilty may have the consequence of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. A broad range of crimes are deportable under federal law. Deportation and other immigration consequences are the subject of a separate proceeding. No one, including defense counsel or this court, can predict with certainty the effect of this conviction on your immigration status. For purposes of today, you are to proceed under the assumption that being convicted of the crime to which you are entering a guilty plea will result in the automatic removal from the United States. And you will not be permitted to return. In short, and regardless of what you may have been advised by your attorney, you will be deported upon conviction of this offense. Do you understand? Do you wish to go forward with your guilty plea regardless of immigration consequences, even if it means automatic removal from the United States and you're not able to return?
Usted quiere continuar con su declaración de culpabilidad independientemente de las consecuencias que su abogado le haya dicho, que puede ser deportado o tener una expulsión automática de los Estados Unidos. ¿No? Yes.
I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom of the page, there are signatures. I recognize this to be Mr. Waddle's signature. But here, where it says defendant, is this your signature, sir? This is an acknowledgement by you that you understand that you have a right, a constitutional right, to have a trial. But when you sign this form, you're indicating to the court that I understand I have a right to a trial, but I'm giving it up. I'm waiving my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes.
Did you sign this form after you spoke with your attorney about your right to a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to have a trial?
So this never happened to me. This is the first time that I am involved with this kind of things. So I just was very influenced by my friends, and I have a family to support. And I promise I will do this again, and I'm gonna make it well.
All right, we'll get to that part in just a moment. I appreciate your statement. Mr. Palacio Gonzalez, I have in my hand a document entitled Entry Withdrawing Plea of Not Guilty. And entering the plea of guilty. It's 3 pages. On the 3rd page, there are signatures. I recognize the prosecutor's signature here, your attorney's signature here, but up here, is this your signature, sir, or is this signature of the defendant?
Pero aquí la también es su firma, donde dice la acusada, que es de my initials.
That's correct. All right, thank you very much. Madam Prosecutor, would you put on the record the party's contention regarding this plea?
Your Honor, the state is going to amend count 1 of the indictment to a possession of criminal tools as a felony of the 5th degree under 29 and 23.24. We understand the defendant will plead guilty to the amended indictment, and there is an agreed recommendation for the defendant to complete the men's extended program as well as aftercare with no 2-for-1s and no 3-for-1s.
Counsel, is that accurate?
Exactly.
Mr. Gonzalez, is that your understanding?
Señor, ¿esto es lo entendido? Yes.
All right. Are you under the influence of any medications, alcohol, or drugs today?
¿Usted está bajo la influencia de alguna medicación, alcohol o drogas?
No.
Have you ever been diagnosed with any type of mental health difficulties?
¿Usted alguna vez ha sido diagnosticado con algún problema mental o alguna dificultad? No.
Are you presently under any type of probation or community supervision in this or any other state?
¿Y usted está ahorita mismo bajo la libertad preparatoria o condicional por otro delito ya sea aquí o en algún otro estado?
I think you see some blood judge.
I have a case downstairs and I've been convicted only for that.
The OBI prior to coming out today, so there's no probation for that.
So you were just put on probation for your misdemeanor case today, correct?
Entonces usted le pusieron bajo la libertad de pruebas por un caso de delito menor de día de hoy, ¿cierto?
Other than that case that you had today, is there any other cases?
Además del caso que usted tuvo el día de hoy, hay otros casos en los cuales usted ha algún tipo de libertad. No.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No.
Are you making this plea of your own free will?
Usted está haciendo esta decisión. Esta declaración por su libre albedrío.
Now, the state has indicated that it is the expectation that you will enter a guilty plea to the amended charge of possessing criminal tools is still a felony of the 5th degree. Is that your understanding?
Es todavía es un delito mayor grave, ese es un dividendo.
Is that what you talked with your lawyer about before this proceeding today?
Es lo que se habla con los abogados acerca de los abogados de entrar a esta diligencia de hoy. Yes.
Now, there is a recommendation, an agreed recommendation between you and the state that you recommend to the court that you are sentenced to the men's extended program, which is an inpatient treatment facility for a period of time. Is that your understanding? Now, I get to decide whether or not I go along with that agreement and how long you'll be in the program if I accept the recommendation. Do you understand? Any questions?
No.
Now, this 3-page agreed plea form you indicated has been translated for you. Is that right?
Este documento de 3 páginas usted indicó que ha sido ya traducido para usted, ¿cierto? Yes.
Do you understand what this agreement says?
¿Usted entendió qué es lo que dice este acuerdo? Yeah.
Do you understand that while you and the state have presented to the court a recommendation for sentencing, that I'm not obligated to follow that recommendation? Do you understand?
Yes.
Knowing that I don't have to follow the recommendation, do you still wish to proceed with the guilty plea?
Yeah.
Mr. Palacio Gonzalez, have you had enough time to consult with your lawyer before this proceeding today?
Yeah.
Has your lawyer answered all of your questions?
Yes.
Have you reviewed and or discussed the evidence the state has against you?
Yeah.
Madam Prosecutor, would you please put on the record whether the state has disclosed all discovery evidence, including any Brady material, if any, to your knowledge?
Yes, Judge.
Mr. Waddle, you acknowledge what you're saying?
We do, Your Honor.
Thank you. Mr. Gonzalez, are you satisfied with your attorney, Mr. Waddle?
Conforme con su abogado, yes, yes.
Now, sir, do you understand the charge of possessing criminal tools, a felony of the 5th degree against you?
Yes.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in this amended charge?
Yeah, yes.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you? And proceed to sentence you immediately?
Y seguir con la imposición de la condena inmediatamente. Yes.
Now, this being a felony of the 5th degree, do you understand that you are facing up to 12 months in prison and up to a maximum fine of $2,500? Did you know that?
¿Usted sabía eso? Yes, yes.
Mr. Waddle, you did fill the form out, appropriately, but could I have you fill out this box here? I'm getting ready to tell them what the, PRC time is. If you violate the conditions of postal use, well, let me go back up. Do you understand that if I sentence you to prison, Mr. Gonzalez, upon your release from prison, you could be on postal use control for up to 2 years?
Lo más rapidísimo es que el ministro carcelario puede estar usted bajo control comunitario hasta 2 años. Yes, okay.
And if you violate the conditions of postal use control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that? Now, sir, I indicated that if I were to send you to prison, upon your release, you may be on postal use control for up to 2 years.
Si yo lo mando y después de que salga usted, yo no pudiese mandar a un control después de la libertad de hasta 2 años este control.
Your attorney put that here on the face of your plea form. Do you understand?
¿Se entiende? Yes.
Are you on postal use control right now?
Usted está bajo la libertad después de la libertad controlada en este momento. Can you repeat that, please?
Are you on postal use control?
Usted ahorita está en control después de haberle puesto en libertad. No.
All right. Do you understand that if you are on postal use control and you are convicted of a new felony offense while on postal use control, that in addition to being punished with a new felony offense, the sentencing court could add an additional 1-year prison term, which would run after your new sentence, or whatever time remains on your postal use control term,
después de la libertad controlada,
or whichever is greater. Do you understand?
el periodo de tiempo que sea mayor que cualquiera de los dos. Okay.
Do you understand that?
Yes.
It may not be something that applies to you because you're not on postal use control.
Okay.
Do you have any questions so far?
¿Usted tiene alguna pregunta hasta el momento? No.
Since this is a felony of the 5th degree, community control is a possibility. Do you understand that I could place you on community control or probation? Instead of sending you to prison.
Yes.
Do you understand that if you are placed on probation or community control, then you will have to abide by all probationary conditions as established by this court? Do you understand?
Yes.
And if I place you on community control and you violate the terms of community control, you'll be brought back before me for a more restricted sanction, which could include, among other things,
que derecho incluye muchas cosas,
the imposition of prison time
la imposición de un plazo nacional
up to the 12 months that I previously talked to you about.
hasta un plazo nacional de los 12 meses que yo estaba comentando.
Do you understand? Also, if I impose court costs and you fail to pay those costs, I could order you to do community service instead of paying the court costs. Understand?
Yes.
Do you have any questions up to this point?
¿Tiene alguna pregunta de lo que vamos a hablar? No.
Now, Mr. Gonzalez, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a right to have a trial, either to the court or to a jury of 12 persons?
Usted está denunciando el derecho de tener un juicio ante ya sea ante un juez o ante un jurado de 12 personas. Yes, okay.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer?
Usted entiende que usted está renunciando al derecho de comunicar testigos que estén testificando en su contra y que su abogado los contrainterrogue.
When I say cross-examine, that means your lawyer gets to ask witnesses questions.
Cuando yo digo contrainterrogar, quiero decir que su abogado me puede hacer preguntas a los testigos de la fiscalía.
Do you understand that?
¿Usted entiende eso? Yes.
Do you understand that you have a right to have witnesses subpoenaed or compelled to come to court and testify for you?
Usted entiende que usted tiene derecho a convocar testigos o mandarlos judicialmente para obligarlos a tener aquí al tribunal a testificar a su favor. Yes.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond reasonable doubt?
Tiene la obligación de la Fiscalía del Estado de Ohio de probar su culpabilidad más allá de toda duda razonable. Yes.
Do you understand that at trial, no one can make you testify against yourself?
Yes. Yes.
Do you understand each of these rights as I explain them?
¿Usted entiende cada uno de estos derechos como se lo acabo de explicar? Yes.
Do you have any questions whatsoever about your constitutional rights?
¿Tiene alguna pregunta acerca de sus derechos constitucionales? No.
Do you understand that if you plead guilty to this offense, you are giving up all of your constitutional rights?
Desde la culpable usted está renunciando a todos sus derechos constitucionales. Yes.
Knowing everything the court has discussed with you today, do you still wish to enter a guilty plea today?
¿Todavía quiere presentar una declaración de culpable? Yes.
A guilty plea to possessing criminal tools, a felony in the 5th degree?
Yes, yes.
Is there anything further from counsel before I accept the plea?
No, Your Honor.
May I hear a statement of facts?
Yes, Judge. On or about December 19th, 2021, in Kansas County, state of Ohio, the defendant did possess any substance with purpose to use it criminally in the commission of a felony in violation of section 29 and 23.24 of the Ohio Revised Code.
Anything on those facts?
No, Your Honor.
Mr. Jensen Palacio Gonzalez, is what the prosecutor said you did true?
¿Es lo que la fiscal acaba de decir, cierto? Yes.
What is your plea to count 1, possessing criminal tools?
¿Cómo se declara al grado número 1 el delito de poseer herramientas criminales,
A felony of the 5th degree.
un delito mayor de quinto grado, ¿cómo se declara?
Pues, no parece ser.
Which one is that one? Is the one with drugs, the charge?
Parece ser. Yeah, but we'll explain her.
No te quedes. Oh, yes.
What is your plea to count 1, possessing criminal tools, felony of the 5th degree?
¿Cuál es su declaración al cargo número 1, posesión de herramientas ilegales, un delito mayor de quinto grado? So that this is the first time it happened?
Well, can you,
I'll explain.
Yes. You guys can see actually.
Tiene que ser ustedes de niños, digamos.
Por eso,
Yes, that's what I'm saying, I am pleading guilty.
your plea is guilty?
¿Su declaración es culpable?
Sí.
Yes.
Let the record reflect that Mr. Jensen Palacio Gonzalez was present in court with his attorney, Mr. Robert Wallace. That Mr. Gonzalez was informed of all his constitutional rights, has made a knowing, intelligent, and voluntary waiver of his rights. The court also notes that Mr. Gonzalez has been notified of the consequence of deportation, exclusion from the United States, or denial of naturalization pursuant to the laws of the United States. The court finds that Mr. Gonzalez understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. Jensen Palacio Gonzalez guilty as to the amended charge of possessing criminal tools, a felony of the 5th degree, in violation of Revised Code 2923.24. Is there any reason why the sentence should not be entered today? Who would you like, are you waiving the PSI?
We can waive the PSI.
Who would you like to say on behalf of Mr. Gonzalez?
Yes, Your Honor. My client's been in this country for a little over 2 years. 3 years ago at this point. He has a host of friends and family that are able friends to help me drive him and mentor him after this. It's been a great help. He knows he made a series of poor decisions. And he now knows exactly how serious he is to treat. He did cooperate fully with the police when the incident occurred. I think at this point, he wants to apologize for taking the time to court, for creating a danger by his actions. He wants to take responsibility in the face of the judgment and punishment.
Anything from the state?
Judge, the defendant was found with cocaine on him during the stop related to an OBI. He was going down the wrong way up one way in Shenandoah. And then we come to an agreement for Ben to extend his judge in the jail. I'll ask you to accept that and send it to him to extend it. I'll ask it. With no 2-for-1, no 3-for-1s, no earlier release, must complete the.
Mr. Gonzalez, this is the time that you get to speak and tell me whatever it is that you want to tell me. So I'll give it to you now.
No, nothing, everything is fine.
Bueno, solo que, pues, como le dije, primera vez que hacer eso, pues, y pues, disculpo, pues, prometo, pues, portarme bien como se me dijo.
So this is as I was telling you, it's the first time that this happened, and I want to apologize, and I just promise to behave well.
The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded. And to punish this offender using the minimum sanctions that this court determines accomplish the purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. And I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors set forth in revised code 2929.12. Accordingly, I impose the jointly recommended sentence of community control with 90 days to be served in the men's extended program. The term of community control will be 1 year. There will be no early release from the men's extended program. Costs will be imposed, no fine. If you violate the conditions of community control, I will impose 12 months in the Ohio Department of Corrections.
Si no cumples las condiciones del control comunitario, poner 12 meses al departamento de corrección.
Do you understand?
¿Entiendes?
Any questions?
No.
You have a right to appeal your conviction and sentence, should you choose to do so.
If su derecho a apelar estos convenios. Usted elige hacer eso,
You must do so within 30 days.
lo tiene que hacer dentro de los siguientes 30 días.
If you cannot afford to process the appeal,
Si usted no tiene los medios económicos para procesar la apelación,
an attorney will be appointed to help you
un abogado se le puede nombrar para que le ayude,
at no cost to you.
sin costo alguno.
Do you understand?
Ok, ¿entiende usted?
I wish you well, Mr. Gonzalez.
Le deseo bien.
Defendant will be remanded until a bed is available at the men's extended program. I believe they have beds available.
Pequeña como para más fácil, para
All right, thank you very much. Good morning.
I did. I'll rest up today. Have a good one.
All right, thank you, Squad. All right, I am ready to get these 4 attorneys in here to figure out the rest of the document. Hello.
Hello, I'm leaving. I don't have this one, then you don't know, I know.
Can you tell all attorneys that you see out there in this town Howard to come on in now?
I'm going to go big it up, so you know, because Lisa, that's not a lot of my home, okay? Yes. All right, thank you.
You ready, Mr. Rubenstein?
Yeah, ready. Mr. Campbell?
Mr. Campbell, Mr. Dillon?
Yeah, I'm trying to hammer out Mr. Campbell's plea.
Okay, well, how long is it gonna take? I mean, it's set at 10, it's 10 after 11, and I have a bench trial today.
Yes, ma'am.
Can we at least do Mr. Dillon real quick?
Yes, sir. I think that's Ms. Oswald's case.
Yeah, Roger.
Oh, okay, good. All right, that's fine, that's fine. I don't think she's out there yet. So you're gonna go and do Mr. Campbell?
Yes, sir.
All right. Good to see you today.
Thank you, Your Honor, very nice to see you.
Thank you.
Thanks for using the microphone. That helps a lot, thank you so much.
All right, thank you. Mr. Lynn, is he here?
He's out like one here to the left part. He said he's up in, your parents.
Sure. We totally lost control. Which one here?
Yes. Yeah, the cables on the, on the track. And we were anticipating having a conference to do something about to, one thing that I screwed, because I know that there was a specification on account for, assuming it's a forfeiture specification. It is a gun specification and a forfeiture specification. So getting my client to understand that he's got mandatory prison time now, has been what I've been dealing with all morning. With the court, it's set for trial, with the court commitment, I know you're trying to get started on the bench. I put it over tomorrow for plea, so I can work with them on this, let them know.
Well, the thing is, I don't know, Ms. Howard, do you have time tomorrow?
Oh, good, let me check. Assistant Judge. Yeah, I have a question.
I understand it's pretty packed, but you have to do it. We do it, we get a lot going on, so if you squeeze it in, you have to be here. I can't do it. Are you pretty confident this is gonna be a free?
It's gotta be, and so, yes, I mean,
Well,
that's part of it, we don't speak the tampering tomorrow, I just didn't realize. It's so rare.
I can say it's unusual that we expect at the tampering, so. I did not even make a check.
Before that, was negotiations about prison time.
This is gonna be the,
Okay.
we haven't, had the discussion, we want to get it.
Yes.
So it's like, we
Yeah.
Agree, one is it.
Yeah. Well, this time, it's a little bit less than about second over, it's because one state go home. I lose my ability to read that.
He fully admitted on these charges, to be honest. And he cleaned it up. We were using it after.
It does have something when you're.
So it's under disability. So now we agree that we have it, that we show.
Okay.
Which is
So there's really, in his best interest to do the.
Well, I said it earlier, you have to be here, here. Okay, so this time we will set it tomorrow. Well, you tell me what you want to tell me, you're going to hear, so I can tell. So this is Karen.
No, needed to check in with you.
Well, neither one of you guys check it with me, then I don't know where you are, or he is, and so this one.
I didn't know that was the rules, sorry. Checked in with Ross, who's here, let me know.
All right, so, we're gonna do a plea tomorrow. All right, this is State of Ohio versus Bobby Campbell, case number B2105-303. Mr. Campbell's present corporal, his attorney, Mr. Scott Rubenstein. This case has in the state of Ohio. This matter is set for jury trial today. This matter has been pending 196 days. And, Mr. Rubenstein, you ready to proceed?
Judge, we are respectfully asking the court to allow us to continue this until tomorrow morning so that we can fully discuss the plea that's on the table at this point. So in a roundabout way, to answer your question, we would know we're not ready, we'd like one more day to try to hammer out the plea.
All right, is that what you're asking, Mr. Campbell? All right. I will set this up for tomorrow at 9 a.m. And I know you've been here a long time, so I'm not stressing the time because you weren't here. I know you were here. But May 10th, 9 a.m. for plea. We'll set it for plea. All right? All right, so we'll see you tomorrow.
Thank you so much.
Thank you. Time wait. Yes, thank you. You speak, right?
Yes, Judge.
You ready?
Ma'am, Judge, can I have one thing that I can, two things. We have a jury waiver on there.
Okay.
And the second thing is he tells me that he had a child care issue with him.
I don't care about child care issues. These child care issues every single time he comes to court. And he knew that this was a trial today, so you took care of it.
Yeah. Well, I would probably be repeating exactly what the court would say, just so you're aware. But, I'm aware of it. The only thing I can
Is
tell
that
you,
somebody with
no, it's just his criminal stuff. But the only thing is, Judge, yes, yes. And I don't know what to do about it right now because he's competent, quote unquote. He's a smart person. Here's what I would tell you, Judge. If the court in any way we give him mercy today as far as that issue goes, he tells me that he thinks he has childcare coming up. I've been, I've had this discussion with the prosecutor, and Judge, if you see the waiver, did you notice how he said it? Without prejudice. So I've had discussions with him, and I believe me, I've run across this issue a couple of times. Can't say that it is something that makes a person incompetent. I mean, the question is whether or not you're capable of assisting in the defense. That's the second problem.
Yes.
No, I'm not. Well, I mean, I'm just talking to the judge, talking to the court in the sense that I keep running a process with him, and I don't know what to do about it. I don't want to. I mean, so I had, once you get rid of this, I have never, but what I would say to the court is, as much as the court would like to resolve this today, I would probably think that I'm a few numbers from my own perspective on it. But in any event, I mean, that's, I just wanted you to be aware that he signed it that way. I want you to be aware there was a child care issue and the court, however.
Okay. You know what,
What do you, I don't know.
I'm gonna bring it in and talk on it, and just be prepared to try to do that, because, I'm frustrated. And who would bring a child to court on the day of the trial? She won't. And what mother,
Just a beautiful little lady.
and what mother would leave their child in his care to go to trial?
Oh, is it child?
Like a little woman. Beautiful little girl.
Okay.
So I mean,
I didn't bring one in.
yeah. I will.
Thank you.
Thank you, Judge.
Uh-huh.
All right, this is a matter of Sable, Ohio versus Kenneth Tye, case number B2103010. Mr. Tye is present in the courtroom with his attorney, Mr. Stephen Wimpy, and Ms. Katie Cash in Sable, Ohio. Mr. Tye, can you go ahead and give your child unattended in the courtroom? This matter is set today for jury trial. And it's how do you want to proceed today, Mr. Wimpy? It's my understanding that the defendant has attempted to execute a waiver of jury trial.
That's correct, Judge. If you recall, the last time we were here, we had a discussion. We're proffering that jury waiver today. Based on the prior discussion, he has executed that jury waiver.
All right. Mr. Tye, is it your intention to have your case tried to the court, that means to me as the judge, and not a jury today? All right. Do you understand that you do have a constitutional right to have it tried to the jury, a of 12 persons. But when you indicate, I want to waive that, do you understand that, now the facts and the law and the application of the law will be all applied by the court? You understand?
Yes,
All right, and that's how you want to proceed?
yes,
All right, I'm gonna have you execute a new waiver, because on the waiver, sir, you put without prejudice. Now, I don't know what you think the law is and what you think those words mean, but all I'm looking for is your signature. If you want to waive, there is no without prejudice. You understand?
Yes, Your Honor, I apologize, I've just been writing anything for a time. You know, I was studying law a little bit, like I'm a legal aid, and I was studying how to reserve your rights, you know, as far as commercial, stuff goes.
Yes, well, that commercial has nothing to do with, this is a criminal matter, commercial is different. But I appreciate your reading up on the law, but that's why you have an attorney to help you navigate through all of this, okay? All right, so I'm gonna get a new waiver form in just a moment. Now, with this being tried as a bench trial on a single count of having weapons following disability, Mr. Ty, today's trial, why did you bring your small child?
I couldn't help you, my fiance asked me to get out until 12, and I was really hoping that she would be able to eat their thing for then. I didn't know that we were gonna have to do trial this early. I thought it was round one. I already thought I'm gonna get to work today because I had trial, and I didn't think I was gonna have her. You know, and I was, you know, like babysitting and stuff, like during this photo time, it's not easy. I'm at 5. She's my youngest baby.
So the other children are at school?
Yes, ma'am.
I see. All right, let's go ahead and get the waiver. And when does your fiance get off of work?
She should be here around 12 o'clock. Hopefully she, you know, found a way to leave early. I told her this was very important. I'll go on her. She knows.
But you just do the one that we did. Have-
Oh, pardon.
It's the same thing.
Okay.
That's the action.
I just put cash out. Yes. Thank you, I appreciate it.
It was my intention to have this case begin this morning, because the court actually has a doctor's appointment, but not until 1:30.
Right, I understand.
And your fiance won't be here till noon. All right, well, you know what? How long do you anticipate the bench trial will be, counsel?
Well, gee, I hate to say this in lawyer's time, but maybe an hour or so. I mean, because generally, you know, things take longer than you expect, but
Yes.
maybe 2 hours.
All
I
right.
think it should be a very short trial. We would raise a legal defense judge, and that would really be.
All right.
Because I wanted to do.
Ms. Cash, from your perspective. All right. Well, we're gonna get started this afternoon. We're gonna get started this afternoon because this case has been pending 315 days. So, we will start at 2:15 and go until the end of the day.
Does I have childcare to the husband of these things
Past 3:30, all right.
And just remind me, I gotta get my kids off the bus at 4.
Sir, your fiance on the kids are
She can do
bus.
that today, actually.
Yes,
I'm
she
sorry,
can.
I was thinking,
That's 2 months. Yeah, okay. All right, 2:15, 3:30. All right, well, recess until then, thank you. All right.
what is his first name? Corey?
Mr. Rubenstein and Mr. Bennett. And I 11:30, right?
Yes, Wednesday, the fall.
Okay. I don't know, is it,
Or is it 11:30 to report it? Do I need to report?
Sorry.
Do I need to report the 11:30?
You said, phone before.
No, you're fine. Appreciate it.
God bless you.
Thank you.
Let's see, all right. So it's your time, and that's gonna be back to 2:15. We got, Mr. Bennett said he was going to be here, Mr. Rubenstein.
Is that also in the jury room, Judge?
No.
No? Okay.
No, she's not here.
Thank you.
Thank you.
No, so basically.
No, this is wrong. Lawrence, state master.
Then the state or judge asking Suzanne is coming by.
Even the state.
Yes. I saw her with the state, she said, well, it's more than she first requested about the state or the prosecutor's and it's covered by. And come back. Because I did ask her, she's sitting before.
Yeah, I was asking. No, no.
She's better.
Where's Mrs. Gash?
She's outside, Judge.
Oh, okay. I just wanted to ask the current, oh, there she is. Has there been any negotiations on the tie case?
One minute, Judge.
Huh?
4 minutes of delegation.
Oh. Okay. Gotcha.
You can recommend, if you can work on this.
Judge, you know, I would say, and I previously had this discussion, maybe we approach. Should we?
Sure.
I guess the question would be if the court had any kind of, I know that we're not necessarily convinced of what kind of sentence it would be, but I could at least inform my client that the court had an inclination for probation on a plea. His last incident was 2011, was the disabilities. I believe there was a weapons under
Yeah, what other weapons understood?
I believe he did at one point, which is, I think his concern honestly is he's terrified to go to prison. I guess he had a, pardon? Okay.
Sorry.
That last came in handy.
Okay, go ahead.
So in any event, I'm concerned. Huh? I think he went up on time. That's what he's just been terrified.
Yeah.
He's got this beautiful baby. Kids. And he does, I will say this, I had that conversation with his boss. He works all the time. The boss came in, that was a point where they hired another attorney. They talked about having a prosecutor for. So anyway, I think he works hard all the time. I was just hoping to see if the court would be inclined to do something with probation. But that was a couple of three, at least I could tell them. Maybe do a clinical evaluation.
I will look into it, but I can do it, whether it's not.
The weapons under
Yeah.
the 2011.
And
I think the weapons under was some time ago. It was a while ago.
because it's right.
So, we have.
I'm gonna look it up right now, Judge, because it's, sorry.
So,
Well, they have constantly on
the disability is a possession of
he says, throwing the token.
being.
Now
And if we get a trial, it's supposed to be. Whatever we find it.
I'm looking right now. Oh,
That's not very.
I think that there was a 2013. That's the That was back in December.